Hello and welcome to our podcast at Get Legally Speaking. Our legal conversation today will be about employment law during the COVID crisis. Backed by the request of our listeners, this is a part 3 of our COVID and employment law podcast, so please do listen to our part 1 and part 2. I am joined by Barrister James Tunley from Lamb Chambers in London. James is a specialist employment barrister and advises and represents both claimants and defendants respondents at all stages of the court and the tribunal process, with particular strengths in employers' liability, discrimination and unfair dismissal, to name but a few. James has delivered lectures and training on bringing employment claims in the county court and on the National Minimum Wage Act 1998. Thank you so much for joining us again, James.
Hello again.
Hello, here we are. I honestly didn't think we'd be back so quickly after doing part 2 employment law during the crisis, but these questions are coming in from listeners, and you know, there's a lot of confusion out there. There's a lot of questions arising, as well as the law changes that are just firing on. So I'm really pleased to be doing this podcast. So let's crack on with our first area of conversation. And that is that a lot of people have agreed to pay cuts or fewer and less days for pay. But if they are then made redundant, should their payoff be based on their original contract, or should it be based on what has been agreed during the crisis, I guess since the lockdown, 23rd of March?
Okay, so there are probably going to be differing views on this, but my view is that it should be based on the original contract. And the reason I say that is that the statutory redundancy payment, that's based on the employee's length of service, their age, and most importantly, a week's pay. And it comes down to how you define what a week's pay is. There's a cap on the statutory week's pay of £538. That went up last month. So you only really need to worry about this if the employee is earning less than that. Otherwise, you're paying at the statutory cap rate. So calculating a week's pay under the Employment Rights Act depends on a few things, including whether or not the employee has normal working hours.
Let me just ask you there, James, when you say your view, your legal view on this, right? This is your legal view on this. So you're saying in terms of should it be based on their original contract or based on what has been agreed during COVID and after the 23rd of March, are we saying actually it should be based on what was going on before the lockdown? Right. So if someone's agreed to fewer days and less pay during the crisis from the 23rd of March 2020, what we're saying is any redundancy package shouldn't be based on that agreement of fewer days and less pay. We're saying it should be based on what the employee was doing prior to the lockdown, right?
I think so, yes, because what the Employment Rights Act says is that if you have normal working hours and your pay doesn't vary depending on the work that you do, then your week's pay is the amount which is payable throughout the employee's normal working hours in a week. And I think that phrase, normal working hours, is key.
That's the key, yeah.
Yeah. There's also a case from 2012 called Dutton and Jones, for those that are interested, which looked at this issue in terms of an employee who had gone on to short time working, which is when your hours are temporarily reduced.
Which is similar to what we're doing now. This is a temporary measure, isn't it? COVID lockdown is temporary.
And in that case, the Employment Appeal Tribunal said that it would be wrong to treat the short time working hours as normal working hours. And it would be wrong to say that the employee has agreed to a permanent change in their contract, including a permanent change to their hours. And I think the same applies here, because people are temporarily agreeing to reduce their pay so that they remain employed during this period.
I think that's key. I think that's absolutely key. And it's got to be right. A temporary measure cannot be reflective of the permanent arrangement. Sure.
I think agreeing to a pay cut so that you can stay employed while this pandemic goes on, and agreeing to, in the event of termination, a reduced redundancy payment are completely different things. And I think if it went before an employment tribunal, they would follow that same sort of logic that we seen in the past.
No, great. I mean, there are clear rules about the redundancy process, aren't there? I mean, have any of those rules been relaxed because of the extraordinary circumstances that we now find ourselves in? Has the Coronavirus Act 2020, I guess, made any provision for redundancy rules and laws to be relaxed?
No, it hasn't. The only change, I think we discussed last time, the only change to the Employment Rights Act has been in respect of this emergency volunteering leave. So all the rules about redundancy, consultation and the process remain unchanged. Policy-wise, that's probably because the government don't want to make it easier for people to be made redundant at the moment. The idea is to keep people in their jobs.
Yes, no, of course. And I think that's really key because, you know, there are law changes out there, and together with what the press report, it's easy to become confused by what's actually the correct thing, what's the correct way. So I think that's a really clear answer to a really, clear question. So the process of redundancy needs to be fair. That's what it says. But who decides what is fair? Is being fair in redundancy defined in employment law in any way? Is there a definition there that people can rely on?
There's not a sort of fixed definition that comes with redundancy. Ultimately, it's going to be for the employment tribunal to decide if it's fair. If an employee disagrees, they're going to bring a claim, and it will be the tribunal who has the say on that. In terms of what is fair, obviously it's a dismissal, so you're looking at the unfair dismissal legislation. But in terms of redundancy, what the employment tribunal will do is take into account, obviously, all of the circumstances of the case and see essentially whether the employer has acted reasonably. And then in redundancy, that generally involves warning employees about possible redundancies, consulting with them before making any final decisions, having a proper and rational basis for selecting. If only certain people are going to be made redundant, how do you select them? Are you doing that in a fair and reasonable way? Do you have objective selection criteria? And then also, have you taken enough steps to look at alternatives to redundancy? For example, finding an alternative role that you can move the employee into.
Or offer the. And I think that in situations like this, it's key to take some legal advice for the employer so that you do get it right. Because there's a lot of time pressure at the moment, isn't there, with employers thinking, right, can we afford to pay? Can we not afford to pay? How do we restructure? What's the right way to do it? And I think there has been an element of shooting from the hip for some employers, particularly large employers who have got large numbers of people to try and manage. And it is a minefield. And there's been some knee-jerk reactions. And I think, what any employer doesn't want is to end up with a bucket full of tribunal cases or legal cases that have been brought out, into from the courts. They just want a smoother transition into what they have to do, whether that's to streamline the workforce or not, as possible. So I would say seek legal advice and seek it before you decide what your redundancy process needs to look like. Seek it before you decide, actually, I'm going to tell that person that I'm reducing their pay, that I'm reducing their days, and this is the package that I'm going to offer, because it could save you a lot of money in the long run if you are faced with tribunal claims and things like that. And then if you're the employee, take advice. Take advice before you accept anything, right, James?
Yes, definitely. I mean, it's always an area that's hotly disputed. And I think because obviously losing your job or dismissing someone is a big decision for either employee or employer. And I think because it's not based on fault, like it's not a misconduct case or anything like that, then it throws itself open to be.
It's great.
Why did this happen to me? And then that's where we'll start looking at, well, why did you make this decision? What criteria did you use? So it's important to get that process right from the start, how you go about selecting the people to make redundant.
Yes. I think that's key. So I would say take advice before you action any redundancy processes if you can afford to do so as a company. And again, as an individual, do some homework, try to take some advice before you accept any agreements, even though, at the time, if you're told you're being made redundant, you could be very upset. Just take a moment, take your time to make decisions, because what you don't want to do also as an individual is engage in litigation. It's very stressful. It could be very expensive and very stressful, and it could prevent you from moving on to your next job if you have been made redundant. No, I think that's great. Let's briefly if someone has a notice period in their contracts, does that take priority over statutory payments, or do people get both if they are made redundant during these times?
You get both. So because you're dismissing for redundancy, employees are entitled to a notice period, and they can either work that period out if there's a job there to continue throughout the notice period, or they can be paid payment in lieu of notice. But
yes,
both payments are equal. Neither one has priority over the other, and they're an entitlement, provided that the qualifying factors for redundancy are met, and that's you've got to have at least 2 years service.
Yes. No, that's very clear. Thank you for that, James. So in some cases, companies are making people redundant via a matrix. They're using a matrix, which HR have been providing line managers and say, right, this is our matrix. This is how we're working out who should go and who should stay. Should the employee be able to see these matrices and any scores that have been awarded, or the workings out of what HR are doing, or how the company are working it out? Is it illegal not to disclose this information to the employee?
Essentially, yes, a fair process. So I remember I talked about a moment ago about having that objective selection criteria. That all goes into the matrix, and then the employees usually get scored against that. And a fair process involves showing them their own scores and where they fell within the calculation.
That must be a tough thing to do. I mean, to get a sheet with your name on it, with some scores on it, scoring you, and whilst you're enjoying work and you believe you produce good work for your employer, that's a tough thing to receive as an employee. So is it illegal not to disclose that to the employee?
It's not necessarily illegal as it's expressly prohibited, but it could make the dismissal unfair. So it's best practice to give the employee their scores so that they can say, well, you got that wrong, I think that should be higher. And you might, as an employer, say, yeah, I think you're right, or no, I'm sticking with that score. It just includes them. It's part of the consultation process as well. And you might want to consult on, well, what are the criteria we're going to use and how we're going to score them, just so that, it helps as much consultation as possible helps, because then it includes them and it makes the process fairer overall. One other point is that a question of whether the employees should see how they fare in terms of what other employees have also scored.
Wow, you're saying that they can have sight of that?
They certainly should. It's encouraged that they should be aware of where they fall in a league table, if you like. So if somebody scored 10 out of 20, for example, are they near the cut-off point where people are being made redundant, or are they sort of way below where the axe falls? And it gives them a chance to see how they fare and make their representations. Obviously, if you're disclosing the scores of everybody in the redundancy pool, then you need to be careful about whether you're disclosing personal data. You need to still comply with the GDPR and the data protection.
That's a very good point, actually.
There are ways of doing it so that people are aware of how they scored in comparison with others.
Yes, no, that's a very good point, because whilst you're disclosing information for one purpose, it's always, I think it's important to cross-check that you're not treading on the toes of another area of law, which you should be considering. And GDPR is a huge area of law that we've also covered podcasts on, both for COVID purposes and in the normal days of life. Okay, so we've already said and discussed that, if you don't disclose matrices and these scores, that could be an angle for an employee to challenge the process as an unfair process. So if a redundancy is challenged and it goes to a tribunal, what would be the main arguments put forward either by the company or by the employee arguing the case? And I mean, that's quite a broad question, I think, because, arguments, and I've certainly seen it in cases that we've dealt with, I mean, they could literally be for many reasons, can't they? But are there any sort of headlines that we could discuss today that could give people just a few pointers on that answer?
Sure. I mean, the obvious point is that to dismiss someone fairly for redundancy, there's got to be a genuine redundancy situation. And sometimes employees will try and challenge this, say that, well, actually, there was no reduction in work or no reduction in the number of employees. It was simply sort of a reorganisation. That is extremely difficult to challenge, because ultimately for an employer, how they how they make their business decisions and organise their affairs is a matter for them, and the tribunal's not going to involve itself in that.
So what we're saying, it's difficult for the employee to challenge the employer in a tribunal on that point. And I think that's a good point you make, because, business decisions are made on so many different, for so many different reasons. It's very difficult to say, it may be very difficult to say, well, actually, their business decision was an incorrect one to let me go, for example, on the basis that, they were restructuring.
Yes, so that's very difficult to challenge. So almost always the focus and the arguments centre on the process that was followed. So that you might get an argument that the pool of employees from whom the redundant employees were selected was too small. So sometimes you can have a pool of just 2 people and you're choosing between 2 people. But it might be argued that, well, actually, it should have included another section of the workforce to include the pool to 10 people. And so for an employee's point of view, they might say, well, I would have fared better if the pool had been 10 people. Bigger. I wouldn't have been redundant. Yes. Or they might say that the selection criteria was too subjective. Or even you get arguments that the selection criteria was discriminatory. And of course, you've always got to be alert to what you're doing, even on the face of it. If it seems objective, does it have a discriminatory effect? So, for example, attendance records sometimes get put into the matrix. So if somebody's got a poor attendance record, they might score lower than someone else.
Because of ill health. And then they could argue, well, actually, that, I had a hip operation or whatever, a foot operation, or I had a genuine sickness that, took me out of work in the last 12 months for 2 months. So that's not a fair way to judge whether I'm a good employee or not.
Absolutely. And then if they've got a disability, which means they've got to take more time off than someone who's not disabled, then they're at a disadvantage. So you've got to make sure it all balances up and that you're not inadvertently discriminating against somebody.
Absolutely. I mean, this is why I said earlier on, I would strongly advise that, legal advice is taken particularly by the employers, but employers, if they can afford to do so, before they execute their redundancy process and even before they engage in it, because they should say, right, what is the right way to do this? What's the first stage we need to do? Then spend their time doing it, rather than get to the end of their process of, okay, we've now got to the end of selection and selecting people for the redundancy process. We're just about to do it. Let's just go and check if what we've done is correct. Take the advice before. It's cheaper to do that. It actually saves time to do that. And the same for the employee. Take advice really, as best you can before you sign on the dotted line or agree to anything. Try not to get contentious. I mean, I know it's easier said than done, but really the long term of being contentious and trying to resolve matters in tribunals and courts are painful for both sides, and only resort to that if you absolutely have to.
Yeah, I think so. And I think you're right to say employees should also consider taking advice as well. Yes, the decision is being made by the employer, but if you as an employee see something going wrong, then say so. Or, for example, if you see a way of avoiding redundancy, so you might say, well, I could do that job, or I'm happy to do that job, even though it might be a lower pay or a lower grade of job, then say so. It avoids the horrible situation of people losing their jobs.
Exactly. I think communication is the key. And like you rightly said, okay, redundancy is down to the employer. However, do speak up if there's things that you feel uncomfortable about. Do try and put your point forward. Do try and resolve matters by taking advice and reiterating that advice to your employer so that you could avoid any contentious and expensive and stressful litigation.
Yes.
All right. Well, do you know what, James? A very good podcast again. So thank you ever so much for your time.
My pleasure.
And you know what? I rock on part 4. This is the we have not had part 4 of any other podcast, so I'm absolutely pleased to be doing part 4 of this podcast because I do think it's incredibly topical and it just affects so many people. You know, there's so many employers out there, there's so many employees out there, and there's some very useful information in this podcast that you've kindly shared with us today. So thank you so much for that. What I will say to our listeners is don't forget to click and subscribe to our podcast. And you can find us on Twitter, Facebook, LinkedIn, Instagram, and YouTube by searching Get Legally Speaking. Also visit our website at getlegallyspeaking.com. Thank you very much for listening.